Good evening. It is now 5:33 on February 8, 2023. I would like to start the City Council successor agency to the Westminster Redevelopment Agency meeting. It's a regular meeting and is on February 8, 2023. Roll call, please.
Thank you. Mayor Nguyen,
Yes, I'm here.
Vice Mayor Nguyen,
Yeah.
Councilwoman Fan West,
Yes.
Councilmember Monzo,
I'm here.
Councilmember Ho. I think I hear her coming. Mayor, you have a quorum,
Thank you.
and Councilmember Ho is here.
Right. Do we have any public comments?
We do have a person with their hand raised. The first person to speak is Westminster Watchdog. Please unmute yourself and you may begin.
Good evening, Terry Raines, Westminster Watchdog. While I have no way of knowing what these two cases of potential litigation are about, I would like to offer some general comments about the agenda item description, conference with legal counsel pursuant to Government Code Section 54956.9 D2, potential litigation, number of cases 2. Pursuant to the Ralph M. Brown Act, local agencies may meet in closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning these matters would prejudice the position of the local agency in the litigation. Litigation is considered pending when a point has been reached where, in the opinion of the legislative body of the local agency, on the advice of its legal counsel based on existing facts and circumstances, there is significant exposure to litigation against the local agency. This is per Government Code Section 54956.9 D2, referenced in tonight's agenda description. Government Code 54956.9E 1 through 5 defines existing facts and circumstances, stating they shall consist only of one of the following. 1, facts and circumstances that might result in litigation against the local agency, but which the local agency believes are not known to a potential plaintiff or plaintiffs, which facts and circumstances need not be disclosed. In most cases, a potential plaintiff is known using the recent billboard dispute that was first listed as anticipated litigation and later as potential litigation. 2, facts and circumstances, including but not limited to an accident, disaster, incident, or transactional occurrence that might result in litigation against the agency and that are known to a potential plaintiff or plaintiffs, which facts or circumstances shall be publicly stated on the agenda or announced. Using the billboard dispute item, the potential plaintiff was indeed known, but was not publicly stated on the agenda or announced. 3, the receipt of the claim pursuant to Government Claims Act, Division 3.6, commencing with Section 810 of Title I of the Government Code, or some other written communication from a potential plaintiff threatening litigation, which claim or communication shall be available for public inspection pursuant to Section 54957.5. Using the billboard dispute item again, allegedly a letter from the potential plaintiff's legal counsel is what prompted the closed session discussion, but this letter was not made available for public inspection. 4, a statement made by a person in an open or public meeting threatening litigation on a specific matter within the responsibility of the legislative body. Using the billboard dispute again, the potential plaintiff actually made a contrary statement at an open session of the city council alleging no litigation was planned. 5, a statement threatening litigation made by a person outside an open and public meeting on a specific matter within the responsibility of the legislative body, so long as the official or employee of the local agency receiving knowledge of that threat makes a contemporaneous or other record of the statement prior to the meeting, which record shall be available for public inspection pursuant to Section 54957.5. Using the billboard example again, to my knowledge, the only threat of litigation was in the form of a letter from the potential plaintiff's legal counsel as referenced above. On February 10, 2020, the First District of California Court of Appeals issued a decision in Fowler versus City of Lafayette. The court addressed the requirements of a local agency's closed session agenda item in order to sufficiently notify the public of threatened or anticipated litigation. The court inferred that a record of litigation threat to be discussed in closed session must be included in the agenda packet and be made available upon request before a meeting. Some public agencies, such as Westminster, when dealing with closed session agenda items for threatened or pending litigation, simply list the number of cases pending and do not provide additional information. The Fowler decision rejected this practice. FYI, most closed session agenda templates provided by law firms in California now include descriptions for existing or anticipated litigation, not potential. And actual practice among many cities in Orange County is to use one of those two terms only, not potential. Furthermore, in meeting minutes, this statement is always included, but no such verbal statement is ever made by the city attorney before the council goes into closed session. Quote, City Attorney Bettenhausen stated the closed session is authorized under California government's section code section 54956.9 D2 because existing facts and circumstances indicate there is a significant exposure to litigation against the city. Any discussion of these matters in open session would certainly prejudice the city's position, unquote. In conclusion, council should direct the city attorney's office to closely review closed session agenda description practice and disclosure requirements and make adjustments in accordance with this cited case law and best practices to avoid any future Brown Act violation allegations. And I would like to ask, I don't know how we can do it, but if you could put the timer up here on Zoom so we can see it. It was there and then it disappeared. So that's it. I'll see you guys later tonight. Thank you.
Anyone else wishing to speak, please raise your hand at this time via Zoom. Mayor, there are no other hands raised. That concludes oral communication at this time.
Thank you. We're now recessed for closed session. Thank you.